This is Todd.
Mr. Michelson, this is Judge Peterson. Can you hear me okay?
I can. Yeah, good morning, Your Honor. Can you hear me okay?
I can. For the record, we are on the record here in what's been styled Nicholson versus Michelson, 2014, 8496. Should have that number memorized by now. I'm still arranging the courtroom a little bit here, so I'm going to make reference to a couple documents and read from a few pleadings, and so I'm getting myself set up to do those things. I apologize for the delay. Gosh, it's been a little bit ago now. I was attempting to print out my outline that I have created for our decision here today, and I promptly jammed the paper in the printer, and luckily Ms. Clark was able to eventually extricate quite a number of accordioned up pieces of paper, and just getting that done. So I apologize for the delay. All right, I think I have my documents open here. For the record, Mr. Michelson is present by phone. He is presently the petitioner, even though styled the respondent in the initial caption. Mr. Michelson does not have counsel. Ms. Nicholson is present with her counsel. And then we have a few other family members who are present as well. Mr. Michelson, is there anyone else there with you?
Yes, my parents and Jolie, my wife.
All right. The children, though, are not present. They're doing their various school activities, I presume?
Yes, that's correct. They're at school, Your Honor.
All right. Thank you. Well, I want to thank the parties. As the court noted at the close of our trial, custody trials are difficult for everyone. They're difficult for the children, which is the court's primary concern. They're difficult for parents and families, and without any doubt, they rank among the most difficult decisions that judges are called upon to make. And the question pending before the court today is whether Mr. Michelson's petition, which requests that I change primary custody to him as part of his request, should be granted, and that's a difficult decision. It's fraught with very real ramifications for both the parents and the children. Of course, it is the parents who have the primary duty and obligation to care for children and to act in their best interests, and even when divorced, to come to agreements on these matters. When parents fail to discharge that duty and cannot agree among themselves as to matters relating to the best interests of the children, then the court is called upon to hear the evidence, to fairly consider the matter, and to decide the case based on settled and well-established law. And this court has done just that. And today the matter is on for me to announce the decision in this very weighty matter in the absence of parental agreement. I want to commend the parties again for their conduct during the trial. I particularly appreciated the parties' answers when I asked each to tell me good things about the other. Trials can often be about the worst when we need to focus on the best, so it was nice to hear both of you say good things about each other. The court heard the trial over 3 days, the 15th, 16th, and 17th of August. The trial was conducted using the formal rules of evidence, except as modified by Family Law Rule 102. The court even permitted the parties to address the court directly at the end of the evidence regarding factors relevant to the court's decision, in the hopes that both parties will feel that they were able to say everything they wished to say consistent with the rules of evidence. And there is some wisdom as a judge in understanding that the cases you preside over are not really your cases, because this case, frankly, is yours. It's yours, Todd, and it's yours, Tina. It's not mine. It's your family. They're your children. When Rosalie has her heart broken for the first time, she's not going to cry on my shoulder. She'll cry on your shoulders. And when the boys skin their knee, skateboarding. I'm not going to put a Band-Aid on it. You will. And as a result, consistent with the rules and the law, the court permitted a full airing of the issues, and it's my sincere hope that in allowing such an airing, I permitted each of you to have your day in court and to bring closure to this chapter, because a trial really can be a therapeutic transition, and I hope that it has been, or that at least it will be, even if not immediately perceived as such, perhaps later when viewed in hindsight. Following the close of evidence on the third day of trial, the court heard the argument of parties. I took the matter under advisement. I reviewed all the exhibits admitted, and a detailed record was made of the documents admitted at the conclusion of the trial. The only inconsistency that was determined is that I don't know that there had been a motion related to Exhibit 17, but again, because Mr. Michelson, that was one of the medical documents that was otherwise contained in the record, the court directed Ms. Clerk to consider that admitted, even though there had not been a formal request there. I did that just for completeness of the record, but there was a lengthy record made at the conclusion of our hearing regarding the evidentiary record. The court set this decision quicker than I normally would, and I expended significant hours in the evenings and on weekends to prepare so that I could have a decision for you folks prior to the end of summer custody time. I say that not for any aggrandizement of myself, but only because this is a significant matter. And I think the two of you deserve no less. The court also appreciates the presence of family and friends in this matter, and as in all custody cases, these issues are of great importance to both parties. Having taken the matter under advisement, it's now on calendar today for my decision, and the following oral pronouncement shall serve as the court's findings of fact, conclusions of law, and memorandum of decision and order of the court. All of my findings today are made to a preponderance of the evidence standard unless otherwise required by law or otherwise noted by me. I weighed and determined the testimony of the various witnesses, and where there were conflicts in the material testimony, I determined said facts in light of the witnesses and testimony the court believed to be more credible, sitting as finder of fact. As I've done before, I'll refer to the parties in this decision primarily by their name rather than their role as petitioner or respondent, since over time and in various states, each party has been in both roles. Therefore, Mr. Michelson, present petitioner, will be referred to either as petitioner, though rarely, and more commonly Mr. Michelson or Todd or even father or dad. Ms. Nicholson, the present respondent, will be referred to on occasion as respondent, but more commonly as Ms. Nicholson or Tina or even mom or mother. And again, I'll use those names rather than their roles of petitioner or respondent wherever possible to avoid confusion. I also feel compelled to state that I have profound respect and empathy for both of you two. Even though my job requires me to weigh and evaluate testimony, please understand that though I am a judge, that's my occupation, I do not judge either of the two of you as people. That's not my role. I certainly personally believe strongly there'll be a final accounting of our earthly matters, but that judgment is far beyond my jurisdiction. My job today is simply to resolve the issues of custody fairly, guided by law, because the two of you cannot agree. In doing that job, however, I'm required to weigh and evaluate evidence, and that will, by necessity, require me to make some comments and observations from my perceptions of the evidence. I don't intend those to be personal criticisms. I don't mean them to be in that way. And as I preside over a difficult case like this and cases like it, I am reminded just how frail and imperfect we are as human beings. So please don't take my evaluation of things today as personal attacks. I certainly don't intend them in that way. There are a few other preliminary matters I needed to take up. I'll note that Tina, your counsel, encouraged and permitted the court to rely on evidence presented at the prior trial. I've generally refrained from doing that, limiting my decision to what was presented at this trial, though I did at times consider such evidence in this decision. I used it mostly to help frame and understand the present circumstances. I sat in the unique position of finder of fact, able to observe the demeanor of the parties and the witnesses and assign weight to their testimony and evaluate the various exhibits and the weight to which they're entitled. If in this decision I highlight certain facts as opposed to others, it doesn't mean I didn't consider the facts I didn't mention. Similarly, if I highlighted a particular claim or argument or exhibit, it doesn't mean I didn't consider all the claims and arguments. I certainly did. The court considered and weighed all the facts and evidence and all the claims of the parties. Also, the court perceives the decision I make today to be a discretionary decision. I intend to act within the boundaries of discretion, consistent with the legal standards applicable to the choices before me. I intend to do so by an exercise of reason through the application of the facts as I've found them and the weight I've given to them to the guiding law related to each issue. I did want to make a preliminary comment regarding support. The court did not consider issues of support. Those were not raised. They're not before this court. In fact, they're subject to an order from another state. So even if the court is to make a change in the custody arrangement here, this court isn't empowered to change whatever the support order may be at this time. I also need to review the procedural history of this matter, and I'm going to do so in greater detail than maybe I would in other cases, just because of its importance. This case comes before the court with a long and seemingly intractable history of conflict. And this background is important because, unfortunately, it frames and informs many of the present issues. The parties were initially divorced in Arizona in 2007. Following a trial, the court awarded custody to Tina with visitation to Todd, noting even at the outset that there is, quote, there is no evidence the parties are able to cooperate and communicate with each other to the extent necessary to make joint decisions in the children's best interests, end quote. That 2000 comment, unfortunately, has proved to be prescient. Subsequent litigation arose in Kansas, where the parties eventually stipulated and agreed to the entry of an agreed order on August 2nd of 2013. As part of that agreed order, they agreed Kansas had jurisdiction, custody should be joint, legal, and physical pursuant to a schedule, and that the parties should enter into a process that Kansas calls case management, which is a system similar in some ways to Idaho's parenting coordinator process, whereby a professional assists the parties with parenting disputes and is authorized to enter recommendations which can become orders of the court. An order for case management was entered in August of 2013, assigning the matter to a Dr. Lance Parker as the case manager. A number of interim orders were entered by that case manager regarding things such as school choice for the children, as well as holiday visitation time, issues which plague the parties still today. Most recently, the case manager entered a case management order dated October 16th of 2014. That order has been admitted as Mr. Michelson's Exhibit 5. That case management order further documents the continued issues with co-parenting, and I'll read from portions of Exhibit 5 Dr. Parker's comments. I'm referring starting on page 3 and 4 and continuing on. In subsection or paragraph 3 on page 3, Dr. Parker notes, since being in case management, complaints by both parents have been the result of poor parental communication, lack of consistency, and a knee-jerk reaction to interpret all matters in the most negative of lights. For example, Tina expressed concern over the children's stress, and the case manager advised her to enroll them in therapy. When Todd discovered she had done so, he complained she had done this without consulting him. He surmised he was intentionally cut out of the loop in another instance of parental alienation. The reality does not appear so, as Dr. Parker then observed. Neither parent is from Kansas, therefore they do not have familiarity with the Kansas legal guidelines. Mother assumed that since case manager said she could enroll the children in counseling, that the counselor or the case manager would inform the father. However, that's not the case manager's role. Apparently, the attorneys had not informed their clients about joint legal custody. Once this was explained to Mother, she informed Todd of the names of the counselor and apologized for the error. Of course, joint legal custody directs the parents to consult and confer regarding major aspects of the children's lives. Therefore, Mother should have discussed her desire to enroll the children, but she's not obligated to necessarily seek Todd's permission. In the process of conferring, the hope is the parents will reach a mutually agreeable decision. But if they do not, mother may announce that she plans to enroll the children in counseling anyway. Now that father is aware of the actions, if he feels strongly, he can file a motion or make a request to the case manager to order mother not to proceed with counseling. This confusion is evident in other issues as well. It appears, however, after a few months in case management, the parties developed an understanding. And Dr. Parker went on to believe that some of these other confusions were errors and not premeditated or spiteful actions. The problems with communication, as I noted, were attributed to confusion and did not at that time seem to Dr. Parker to be intentional actions by Ms. Nicholson excluding Mr. Michelson from his proper parental role. Dr. Parker did make some other observations that are relevant here in paragraph 5 on page 4, that father did not see the children for 2 years prior to 2013. Father also reported that his parenting time allowed him to work through many of the difficulties he had with the children that were the result of long absences. Father also had concerns that mother was directing access to counselors and providing biased versions of events. Dr. Parker addressed those. And then Dr. Parker noted that psychological testing found both parents have weaknesses that they would benefit from working on in a therapeutic setting. Ms. Nicholson objected to the case management order, and the court in Kansas held a hearing regarding Ms. Nicholson's objection on December 2nd of 2014 and overruled her various objections and confirmed the case management order as the order of the court with a few additional terms by an order dated December 2nd, 2014. That December 2nd, 2014 is not in the present record, but the court is aware of it and takes notice of it. Those orders, the case management order, which is Exhibit 5, and the various additional terms from the order entered December 2nd, 2014, constitute the presently operative custody orders regarding the parties' minor children. A mere 10 days after her objections were overruled in Kansas, Ms. Nicholson filed another action here in Idaho, seeking to essentially, at that time, relitigate the Kansas order. Her petition sought sole custody of the children and to substantially reduce Mr. Michelson's custody time. Mr. Michelson's response was only to ask that her petition would be denied. He did not himself seek for custody to change. It was then that this court became involved. Following a litigation where it was determined that Idaho would have jurisdiction over the matter, this court entered an order assuming jurisdiction on or about November 6th of 2015, adopting the prior case management orders. And it was during that process that the Kansas court expressed concerns regarding parenting time for Mr. Michelson, as has been previously noted. In fact, while the matter was pending here for trial in Idaho, on Ms. Nicholson's petition, Ms. Nicholson also brought another action. She brought an action for contempt against Mr. Michelson. Ms. Nicholson's petition came before me for trial. At the conclusion of the trial, I denied the petition to modify, and I made a number of findings in denying her petition when I entered that order in 2016. I noted at that time that Mr. Michelson demonstrates significant insight into the proper needs of the children. I was impressed with the family support for Mr. Michelson. I commented on their family meeting. I found that if things didn't improve, the solution would be more normalized time with Todd, not less. And I asked Tina to support a more normalized transition where the children can have confidence and not have a clinging dependence on mom. The court also noted that Todd Michelson's parents, Mickey Michelson particularly, rather succinctly saw what Tina did not, and that is that Ms. Nicholson, in this court's view, had created an extreme loyalty bind for the children, where they're torn between their mother's needs and their desire to see their father. In that prior case, I was also extraordinarily impressed with Jolie Michelson. I put great weight in her testimony. I put great weight then in her description of the home dynamic with the children, the summer visitation time and it being successful for the children, but providing yet again another example of Tina seeing everything in the worst light possible, echoing the prior comments of the case manager, Dr. Parker, from his prior findings. I also found during that matter that Ms. Nicholson does not display the same insight as Mr. Michelson. Instead, I noted that she had enmeshed herself and now, unfortunately, the children in what I described as a siege mindset, where she has done no wrong and all the ills are laid at the feet of Mr. Michelson. I also specifically found that she created, fed, and nurtured the stress and anxiety of the children, and then attempted to use that stress and anxiety as a basis to modify the custody order, showing a significant absence of insight into the best interest of the children. I also noted that the solution, if matters did not change, was more time with Mr. Michelson, not less. I mentioned that more than once in my decision. The court also mentioned strongly Tina's decision over Rosalie's counseling. As the parties may recall, Rosalie was in counseling, and the court was able to view those counseling records. In those records, Rosalie referenced multiple times how she wanted to see her dad, was excited to see her dad, and believing her comments to be private and to her counselor, she told the counselor how hard that was for her to tell her mom that she loved her dad because of how mad that made her mom. The second Tina found out these things were being said and that Todd might learn of them, she unilaterally removed Rosalie from counseling and did not re-enroll her. The court cautioned her strongly about that. Also in the counseling notes was a picture Rosalie had drawn, one of the most sad pictures I've seen drawn by a child. And unfortunately, my experience both as a sex crimes prosecutor and as a family law lawyer and now as a judge, I've not encountered no shortage of heart-wrenching information from children. But Rosalie's picture was one I'll likely never forget. It was a picture of her heart in a cage, surrounded by cameras and other things. The court noted that I felt Tina lacked insight to see that that came from her actions, not, as she wanted me to believe, Todd. I told Tina in that decision that I hoped she would see what she was doing. I felt she had removed from Rosalie any chance for Rosalie to speak joyfully about her father and to express love for him. Rosalie previously had the safety to say those things to her counselor, and I believe those things were the feelings of her true heart. She was torn. She wants to see and love her father, but she knows that it hurts Mom, and that's what we call a loyalty bind. And in response to that, Mom took away the confidential setting for her to freely discuss those feelings. And worse, Rosalie learned that you, Tina, had found out what she said to the counselor about her dad. I told you that in my view, Rosalie was a child who literally was not able to say what she felt because she knew you were watching and you will find out. It was no wonder to me that she drew her heart in a cage with locks and video cameras. She had been telling her counselors how excited she was to see her father, to take hip-hop dance classes, but she was afraid to tell you those things. I noted in my prior decision that never in all my years had I seen a child as blatantly enmeshed in one parent's message as Rosalie was in yours, and I was convinced, as I noted, that she had no forum to express her true feelings, and she feared repercussions. I told you that it needs to be okay for her to love her dad, and you need to make it okay, not just by words, but by actions. I asked you please not to put your fears about Todd into them, and to let them fly, not just to let them sing. I also observed that none of the children were in counseling, despite Rosalie's counseling notes being relatively positive. I commented to you that if you were concerned about their best interests and truly believed stress and anxiety was an important factor for them, they would all be in counseling, and yet they were not. I further observed at the last hearing that you, in my view, were smothering these children under the guise of love. And I mentioned that I felt you nursed and fed concerns regarding illnesses and injury. I even commented on the telephone schedule and the need for that. I ended that decision, though, with hope. I informed you that I felt you needed to change your approach. I also stressed that I saw there was no reason that that couldn't happen. I felt you both were smart, educated people with good homes, new relationships, no addictions, no mental health issues, no criminal behavior. I think it was pretty clear I expected the children, or at least Rosalie, to be enrolled in counseling right away. I also mentioned to both of you that I could have done a shorter decision and made it plainer or simpler, but I wanted to give specific guidance to the parties in an attempt to be helpful as to what needed to be changed. I think I was very clear with what the court saw as issues needing to be addressed, and I think I noted several times that if that approach didn't change, the most likely solution would be more time with Todd, not less time. I go through this procedural history for various reasons, not to criticize you, Ms. Nicholson, or to lecture you in any way, but to remind of what has gone on before. And it also, I think, serves two other purposes. First, I think it helps illuminate Ms. Nicholson's mindset for the court for the present circumstances. For example, I'll turn to the pleadings and the declaration in support of your summary judgment motion that caused me some trepidation when I first saw them here in this case. Excuse me, let me retrieve that here. I scrolled down too far. There you go. The introductory material in these moving documents are alleging that, quote, this is yet another unfortunate attempt by Mr. Michelson, his third in 10 years, to harass his ex-wife, Miss Nicholson, by filing a frivolous request for a change of primary custody of their 3 minor children, respectively. It is the same repetitive, ongoing poor parental communications, lack of consistency, knee-jerk reactions, and personal differences with new dates and newly manufactured allegations of impropriety. Reviewing the procedural history until this recent petition, since 2013, Ms. Nicholson has entirely been the source of litigation. She objected to the case management order. She filed an action in Idaho seeking sole custody. She brought an action for contempt against Mr. Michelson. During all that time, Mr. Michelson did nothing but ask that her request be denied. Yet in her moving papers, she attempts to paint a picture that she is the endless victim of Mr. Michelson taking her back to court again and again, when in reality, before this court and in recent history, none of that is true. She has been the initiator of all legal actions up until this last petition. This is exactly the siege mindset that I was referring to in 2016. And unfortunately, it appears that this sort of false impression of her as the persecuted victim is something that she has characterized to persons who have supported and assisted her incorrectly. Of course, I don't mean to suggest Tina should in some way be punished for frequent litigation. Parents should always feel free to seek redress with the court when they feel the need warrants it. I mention this only to help understand Ms. Nicholson's creating and perpetuating a false picture that she is a victim of Mr. Michelson's frequent litigation. That's simply untrue. Second, and the court notes that all of the actions that have been brought by Ms. Nicholson, her objection to the case management order was denied. Her petition was essentially a relitigation initially of matters in another state, which is improper. Once amended, it was denied as not being proven, and even her contempt matter was dismissed. Second, the procedural history and the continuation of the long-standing issues helps the court understand more recent events. Dr. Parker noted back in 2013 that when Tina was doing things unilaterally without consulting Todd, Dr. Parker advised you not to do that. He advised you what joint custody meant. He made it clear what you were doing was wrong and not in the children's best interest. But since that was the first go-around, he gave you the benefit of the doubt that once you had been informed of how things were supposed to work, you would not do them that way anymore. Unfortunately, that unilateral conduct continued through the last trial, and evidence demonstrates that it continued consistently thereafter throughout this trial, which I'll detail more fully below. This history aids the court in determining that your conduct is no longer accidental. The history also shows that for a period of 2 years, Mr. Michelson was not able to see the children. I know, Tina, you attempted to dispute that at the last trial, but I say again what I said then. Those were the findings of the Kansas court, and this court is required by law to adopt them. But again, this history is just framework. It's meant to understand the present. It's a framework of conflict against which the instant litigation has been brought. So we'll turn to the present litigation. Following the denied ex parte motion, Mr. Michelson filed his petition for modification on February 12, 2018. Ms. Nicholson filed her pro se response on March 19th of 2018. Counsel subsequently appeared and filed a notice of strict compliance with the rules of evidence, and then a motion for summary judgment, which the court ruled on at the beginning of trial. Mr. Michelson's petition alleges substantial material and permanent changes of circumstance warrant modification, and the best interests of the children warrant that the schedule be essentially reversed. He be awarded primary on-duty parenting time during the school year, and in his request, sole custody with a proposal of supervised visitation for Ms. Nicholson. Ms. Nicholson, in her response, requests the petition be denied and that the present order stay in place. She does not herself request changes to the present order. I'm going to review then the testimony of the witnesses at trial and the court's impressions. The court first heard from Tina Nicholson. Though she did her best, the court did believe her testimony was not compelling, and it was invasive in parts. She had difficulty recalling events and things that should be at the forefront of her mind. She was, for example, unsure and vague about counseling for the children. She did not know Rosalie's present caseload or her academic accommodations at Lake City High School. She claimed confusion about her actions in unilaterally enrolling Rosalie in charter without consulting with Todd. To this court's view, she mischaracterized email communications. She claimed to have communications that she could then subsequently not document. She was impeached by Mr. Michelson effectively on several occasions. The court found these inconsistencies and lack of memory to be strategic on her part, though some of the difficulty in testifying can certainly be explained in part by the stress of custody trials generally and having to answer questions from her former spouse directly, and the court certainly feels empathy for that. It does not sufficiently explain our many testimonial difficulties. As the finder of fact able to observe her credibility and demeanor, the court did not find her testimony credible in areas where it contradicted other witnesses or evidence, and the court resolves factual conflicts between her testimony and the testimony of other witnesses against her. The court also found Ms. Nicholson to be exaggerated in her views regarding the children and their wishes, as opposed to Mr. Michelson, who was much more measured and realistic. For example, where Mr. Michelson agreed a change of custody might help Rosalie, might be difficult but beneficial for Christian, and then, of course, more difficult for their youngest son, Ms. Nicholson saw no value in the change and believed they all wanted to come home and had no desire to be with Dad in any way. The court finds, again, as I did before, that Ms. Nicholson continues to lack insight into the children beyond believing her version of how she wants things to be. The court also attributes Rosalie's very unusual reversal of concern in her phone call to Todd to the same historic loyalty bind that Rosalie has been put in the past. There is really no other way to make sense of a child calling in distress, as was testified to, only to call the next day and say she was just on her period and everything's fine. It's clearly not fine. Ms. Nicholson refuses to see the conflict from her interactions with police or the negative situations created by conflict with the school. Everything in her mind is everyone else's fault and everyone is against her. The principal at Coeur d'Alene Christian Academy, the teachers at Charter, the system. Again, she lacks insight into the needs of the children and maintains the siege mentality I described previously. And the court found it illuminating that the majority of her comments and arguments focus not on best interests of the children, but focuses instead on how everyone is blaming her. A parent that's more focused on not being responsible for what's going on is not a parent that's acting in the best interests of children. It's also clear to this court she has toxically failed to co-parent. She took medical action without properly involving Todd. Though Todd's concerns regarding the medication may certainly be overblown, and the court finds that they are, it's nevertheless Tina's obligation to consult with him prior to starting Rosalie on such medication. She enrolled Rosalie in Charter months earlier and waited to discuss it with Todd until after she had been accepted, putting Todd in the unenviable position of having to say no or raise objections, further undermining the relationship between Todd and Rosalie. She involved law enforcement regarding Rosalie without informing Todd, clearly in violation of her legal obligations. She enmeshed Rosalie in unnecessary conflict with the Christian Academy, which resulted in her not being able to enroll there. She didn't tell Todd about Rosalie's increasing problems. Todd didn't learn about these things until after he was called by Rosalie. And the court finds unpersuasive the suggestion that somehow Todd failed by not coming to Coeur d'Alene to address these issues. Given the relationship between the parties, I think that would have achieved nothing, and I don't believe Tina would have welcomed or permitted his presence. Further, the court found Tina was evasive about counseling and conveniently permitted Rosalie to direct that she didn't want to go to counseling. That's not how a parent handles the matter, given the history here. The child does not decide. Of course, Rosalie's stated reluctance provided Tina with a convenient reason to not have her in counseling. That's inexcusable given the past history. Again, Tina selected a counselor without consulting Todd when she finally did choose a counselor. Of course, her excuse at trial was that she thought Todd would want Rosalie in counseling, so that should be okay. But this is exactly the same issue that arose in 2013, and she knows she's not permitted to do that. Past events demonstrate only one possible reasonable conclusion, that Tina is, as Todd claims, intentionally doing these things to keep Todd out of the decision process. Additionally, there appears to be no consistent dedication to counseling despite Rosalie's significant struggles. Also, the boys, though their need is certainly less apparent than Rosalie, they've been referred only to pastoral counseling, which, while the court appreciates the benefit of faith-based programs, is simply insufficient to meet the needs of the children here. Tina's explanation for things also are contradictory. For instance, sometimes materials indicate she's alleging bullying from classmates as a reason for a change of schools. Then in other communications, that's not mentioned at all, or it's even denied. As noted by Todd, the stated reasons for transfer was volleyball and music. Those were never actively or meaningfully pursued. Additionally, the court is gravely concerned by the concussion incident. What appears to be a schoolyard incident of a ball being thrown has now turned into a near 2-year reason for Rosalie to be in her present circumstance. And Todd is rightly concerned that there's no significant plan of action for Rosalie. Todd's suspicion that this medical issue is being used by Tina as a perpetual excuse and a nurtured weakness is consistent with Tina's prior behaviors and is exactly the type of issue the court referred to previously. Todd suspects that Tina has a strategic reason not to have this issue resolved, as it keeps Rosalie forever dependent on Mom and keeps a perpetual excuse for her to be involved. This is echoed by the testimony that Rosalie responded to her mom that she's always trying to keep her down. The court finds merit to Todd's views, though candidly the matter cannot be conclusively resolved as none of the medical witnesses testified. Of course, to the extent there are concussion symptoms, the forced choice of enrolling her in charter was the worst possible decision for her, which proved to be true. In the end, we had a very academically inclined young lady who was kept home from school longer than needed, and the court interprets the medical documents as Todd does. She went to a school she wasn't ready for. She was unable to return to the school where she had previously thrived. She's apparently been recently taking fewer classes than she could clearly handle, as appears to be apparent from her current schooling in Arizona, and is now a grade behind her class by credit. Tina did not recall how many classes Christian failed last school year. She did not know what classes Rosalie was signed up for at Lake City or whether she was on a reduced load or not. These things are inexcusable under the circumstances. Ms. Nicholson, however, does not see how she plays a role in any of these failures. In fact, when directly questioned, despite not telling Todd about police involvement, depression, medication, school enrollment, and other things, Tina testifies that she did not believe she left him in the dark regarding these matters, when it is clearly true that she did. Instead, she characterizes Todd's communications as improper, pointing to the emails she admitted. The court reviewed those and comes to the opposite conclusion. While certainly at times Todd could be less frustrated in his communications, he asks questions, he asks to be involved, he makes reasonable requests. When he takes Tina to task in an email that is well-deserved and measured, he points out actual blatant failures of her co-parenting. She doesn't respond to him when he asks questions. She doesn't provide information, instead relying on the school or the doctor to do it, as is exactly the same alleged confusion she had back in 2013. This is unreasonable. In her testimony, she stated the emails show the nature of their communication for the last 10 years, suggesting somewhat ironically that they show Todd's poor communication, when in this court's view they demonstrate hers, and there is no sign of this abating in any way. Rosalie herself also noted through the testimony of the witnesses that she wants to do more than she is allowed. And of course, strangely, or perhaps not so strangely, her symptoms all but disappear when she is with Todd. Of course, again, the court is hindered in that the medical witnesses did not testify. The court only had their documents, which are based in large part on Tina's self-reporting and Rosalie's self-reporting, which, as with all other things, is done knowing what mom clearly wants her to say. Todd correctly points out several rather telling issues where there's a crack in the armor, such as where Rosalie admits some of the issues she's having maybe from school and lack of success and not from the concussion. As Todd made clear in his questioning of Tina, there is really no plan to advance her wellness. The court heard from Jolie Michelson. The court put great weight in her testimony, found her credible and believable. Her recitation of the family dynamic and the children during their summer visitations was detailed and thoughtful, showing an understanding of a proper parenting dynamic. To the extent her testimony conflicts with her testimony, the court resolves that conflict in favor of Jolie's testimony. The court heard from Jeff Michelson, and Mr. Michelson's testimony was limited in that he was not permitted to testify as an expert, of course, with appropriate basis under the law. However, the court certainly notes his great experience with children and is familiar with Mr. Michelson from prior testimony. The court put weight in his testimony, even though limited, and believes he and his wife can be excellent resources for the children should a change of custody be granted. Further, the court put weight in his observations of Rosalie at volleyball. The court also heard from Todd Michelson. Once again, the court noted Todd displayed significant insight into the well-being of the children, which is a historical observation of the court. His testimony and approach shows that insight. Even the way he speaks about the children reflects an interest in their welfare with a degree of insight Tina seems to lack, unfortunately. For instance, as mentioned above, the court found very honest his assessment that if his request was granted, it will be particularly difficult on their youngest son. The court puts great weight in this testimony, and the fact that he can articulate that rather than saying the opposite of what Tina said, which is to say, no, everything will be great, Judge, if you make this change, leads the court to have great confidence that Todd will recognize and address any concerns or struggles that the children may have, and they will react differently if a change is granted. Again, the court put great weight in this testimony, and while some of the emails the court reviewed show Mr. Michelson's frustration, the court notes that that frustration is to some degree unfortunately warranted by what is now proven to be years of toxic co-parenting and undermining of his relationship with the children for all the reasons previously commented by the court. To the extent his testimony conflicts with other testimony, the court resolves the conflict in favor of Mr. Michelson's testimony. Ms. Nicholson also brought in several other supporting witnesses, and the court appreciates their testimony, though it is limited in some sense and doesn't really address the issue that the court is addressing here today. The court also found their testimony to be in part colored, as it is, by Tina's incorrect portrayal of herself as the victim. Again, I thought many of their comments were limited and supportive, which the court appreciates greatly, but they're focused on the wrong issue. Certainly, Tina is a good mom. She handles the issues life is thrown at her. She gets the kids where they need to go. She prioritizes them in her way. She tries to meet and does meet their needs. What she does not do, though, is foster an appropriate love and respect in relationship with their father. And the witnesses had little to offer of relevance on that issue. Some lip service to loving their dad is one thing, but the actions and decisions she take clearly demonstrate something different. They also had little insight really into the toxic co-parenting and no understanding apparently of the historical issues. As such, the court cannot put significant weight in their testimony as it related to the issues before the court. The court does, of course, though, appreciate their love and support for Tina and their love and support for the children. They certainly have been a great benefit to Tina and to the children. I'll turn now to the issues at hand. The first question is substantial material permanent change of circumstances, whether those have been demonstrated sufficient to warrant modification. The court's guided by Idaho case law in this matter, which I've recited before and I'll recite again. A divorce decree granting custody of a minor child may not be modified unless there's been a material, permanent, and substantial change in conditions and circumstances subsequent to the entry of the original decree, which would indicate to the court's satisfaction that modification would be for the best interest of the child. That's Tomlinson versus Tomlinson, 93 Idaho at 47, a 1969 case. The party petitioning for the modification bears the burden of proving that substantial and permanent changes occurred. Chislett versus Cox, 102 Idaho at 298. The court is most guided by a recent Supreme Court decision in Evans versus Saylor, 151 Idaho 223, a 2011 case. It's well known to this court, and it summarizes how the court is to go about finding whether or not changes are established as substantial, material, and permanent. The court has made it clear that whether those changes are material or substantial depends on the impact of the change upon the child. The Idaho court addressed that subject in Posey versus Bunny, 98 Idaho 258, and also cited in Evans versus Saylor, noting that while the material, permanent, and substantial change standard is a sound legal principle, care must be exercised in its application. The tendency is to search for some greatly altered circumstance in an attempt to pinpoint the change called for by the rule. Thus, the emphasis is placed on defining some change and making that change appear to be material, permanent, and substantial. This focus is misleading. The important portion of the standard is what relates to the change in conditions to the best interest of the child. The change circumstance standard was designed as a matter of policy to prevent continuous relitigation of custody matters. That policy goal, however, is of secondary importance when compared to the best interest of the child, which is the controlling consideration in all custody proceedings. The court must not only look for changes of condition which are material, but also must thoroughly explore their ramifications vis-a-vis the best interest of the child of any change which is evident. And this, I really think, is the key language. What may appear by itself to be a small and insignificant change in circumstance may have significant effects insofar as children are concerned. And care must be taken to avoid compartmentalizing consideration of the best interest in successive attempts at custody modification, which we have here. The best interest of a child, like that child's growth, is a matter of development. An emerging pattern which is not apparent in a first consideration may come into focus at some later time. The court should allow and consider all evidence relevant to a child's interest, not just that evidence which has emerged since previous orders. And I mentioned that when I spoke with the parties and made evidentiary rulings that prior behavior and factors give context to present conditions for the court to help understand them. According to the Supreme Court in Evans, the courts have characterized the holding as the best interest of the child take precedence in any analysis regarding a material change in circumstance. Of course, the best interest factors are contained in Idaho Code 32717 and include all relevant factors. Further, determining whether or not a substantial material and permanent change has occurred is not a question of law. It's a discretionary decision of the court. I perceive it as a discretionary decision and intend to act as I've noted above. We'll turn then to the pleadings, and we'll review Todd's pleadings. Because this is a lengthy decision, I'm not going to cite them in their entirety, but I'll just note in his modification, in summary, in his paragraph 5, letter paragraph A, I believe H, no, through K. He indicates what he believes are the substantial material and permanent change in circumstances, continuing to feed and nurture self-doubt, degrading academic standing, creating loyalty binds with dad, exaggerating illnesses, cultivating neediness, exploiting them for her means, unilaterally enrolling the children into counseling, coaching them as what to say, taking them out of counseling when she discovered they were saying positive things about Dad. Some of these things are historical, of course. He then goes on to allege the changes he's referring to. As of the end of 27, none of the children have returned to counseling subsequent to the court's findings. Again, he makes some historical allegations, but then alleges that Mom has ignored the court's admonition to change her behavior, continuously boxing Dad out of critical co-parenting matters concerning health. Since the spring of 2017, Mom has had Rosalie on psychotropic drugs without Dad's knowledge. She enrolled Rosalie in a different high school without making Dad aware, kept the daughter home from Classical Christian Academy for the remaining 3 months of the past year without conferring with Dad, levered serious allegations against the school without Dad's knowledge, filed several police reports against a classmate alleging stalking, harassment, etc., without ever informing Dad, applied for 504C accommodations without Dad's involvement, refuses to answer questions about the children's home environment. After learning about Mom enrolling Rosalie into a different high school and strongly objecting, those concerns were discarded, and she was started at Charter Academy for the start of the autumn semester nevertheless. After only one semester at Charter, Mom withdrew Rosalie and enrolled her into Lake City. This is the third school Rosalie has attended in less than a year, and the fourth school environment if you include her several months of at-home schooling. This tumultuous situation has left Rosalie with a credit shortfall, officially a grade below her peers. That was paragraph E. Paragraph F, the children continue to be subjected to an unstable home environment with allegations of domestic violence against Mom by her then husband, claims of battery against a stepfather who is absent for months at a time. He makes some other allegations in F which were not addressed by testimony. There was no testimony about a gag order regarding the stepfather or Mom's debilitating health. In G, he alleges Mom has created an acrimonious academic environment such that Rosalie was rejected for re-enrollment in Classical Christian Academy. He notes that the children had failed to combine 9 classes the past year, with Christian ending the school year with 3 Fs, while Rosalie finished autumn semester with 2. In H, Todd alleges Mom has exaggerated Rosalie's alleged concussion, undermining her confidence, leading Rosalie to believe she can't take tests, do homework, exercise, or even be employed. He repeats his allegations regarding the medical restrictions. Some of these get a little inflammatory and I think are beyond what the court would find, but Mom exploited Rosalie's concussions and used for leverage in an effort to strong-arm the school into expelling a classmate. While the court doesn't feel that to be true, certainly Mom embroiled Rosalie in a fight with the school, which backfired in the school's decision not to allow Rosalie to return. She now has been diagnosed as being depressed and having anxiety and taking medication without Dad's knowledge. Here it's clear to the court that there have been substantial material and permanent changes of circumstance. And I think that's true regardless of the measuring event, whether it be from the case management order, which I believe is the proper measure of time, or even if I measured it from the last denial in 2016, there have been significant changes. And they're well documented and frankly not even really disputed. It's only the weight of them that really is disputed. Rosalie has had significant struggles for multiple changes of schools, for injury and medication. The children, particularly Rosalie and Christian's academic decline and failing grades, Rosalie's academic deficits, the involvement of law enforcement without notice to Todd, issues of depression for Rosalie without notice to Todd, lack of counseling for a period of time, and then even once involved, sporadic and inconsistent. The continued toxic lack of co-parenting, which at this point has risen in this court's view to a crisis level. The continued and intentional thwarting of Todd's legal role in the lives of the children. Tina's continued disregard for counseling for all of the children. And though, as I noted, the court is never going to punish her for being a victim of domestic violence, there certainly has been instability and change in her home, and that has been a significant factor. The record contains other factors as well, as argued by Todd, and the court generally adopts Mr. Michelson's position regarding change of circumstances. And I find to a clear and convincing level that there have been substantial material and permanent changes that the children have experienced over time. And the legal standard and that language, I think, is particularly illuminating when I consider it. That the best interest of a child, like a child's growth, is a matter of development. And an emerging pattern, which is not apparent at first, may come into focus at a later time. Certainly, these things have been growing and simmering for some time, and now the court simply cannot ignore them. The next question is the best interest of the children. Having found that there's been a substantial material and permanent change of circumstances warranting consideration of a modification, that does not necessarily mean that the requested change will be made. The court has to evaluate if the proposed modification is in the best interest of the children. And the court is guided here by the best interest factors in 32717. And as I noted, and the parties also agreed, the court is considering the PEA factors since they bear in their own way on this matter. Of course, it's not truly a move-away case, but the Tropea factors were cited with approval when you're considering relocation of children. The factors address those issues helpfully, and they're guiding for the court. I do want to note a few important things at the outset of our discussion of best interests. The court has made much comment about the co-parenting failures here. Please understand that custody of children is not a prize to be awarded to the least culpable co-parent. There are other mechanisms to address co-parenting concerns. However, here, the co-parenting issues have become more than that. The court is unfortunately convinced that in mom's home, there can be no appropriate relationship with dad. Yet the court finds that in dad's home, he will foster a relationship with mom, and that is a factor to consider. I'll turn now to the 717 factors. A is the wishes of the parents. Those are well known to the court and well stated. Todd's reflects insight, in my view. Tina's does not. Todd acknowledges the struggles that a change would make. Todd acknowledges the struggles that the children are experiencing right now. Tina does not. She believes that children just simply want to return home. They don't want to be with their dad. And she has expressed that she believes, while there was a rough patch, things have normalized now. The court does not interpret the evidence in that way. As such, this factor weighs in favor of Todd's request. The wishes of the children, that's interesting. Rosalie has at times expressed a desire to come live with Todd. Certainly that stemmed from an emergency and from a disruption that she had experienced. The court puts weight in those expressions by her. The court does not put much weight in their subsequent retractions. Much like Rosalie's comments at the last trial, denying or distancing herself from what she said to the counselor when she knew her mom was now watching, the court does not put much weight in the phone call saying, well, I'm blaming that on my period. There's less evidence related to the boys. Candidly, most of the evidence relates to Rosalie and her struggles and to some extent to Christian. But the court accepts Mr. Michelson's testimony that Rosalie is excited to be there in Arizona. She has some reluctance for sure. Christian is a little bit more of a mixed bag, and Caleb likely will have some struggles. And again, as the court noted before, the honesty of Mr. Michelson in relating that and the insight to notice that weighs heavily with the court. And I think that statement probably does accurately state the wishes of the children. This court does not believe in separating siblings. I would never do that. And I had to weigh the various requests here because they are different. On balance, though, I believe this factor favors granting Mr. Michelson's request. The next factor is the interaction and interrelationship of the children with their parent or parents and their siblings. Though Rosalie has had some conflict with her brothers, I think they have a loving and successful sibling relationship. I think they have a good relationship with their dad. I also think time and the witnesses have borne out, both at the prior trial and now, that there is a normalizing factor when the children get substantial time with Todd. In fact, even back in the 2013 order, Dr. Parker found that additional parenting time allowed him to work through many of the difficulties he had with his children that were the result of their long absence from him. Similarly, the summer visitations have been successful, as Jolie testified to and as Todd testified to. And again, the court is convinced that in Todd's home, the children will be permitted to love their mother, for the court believes that there is substantial evidence that demonstrates Tina does not nurture a relationship with Todd. That factor also substantially weighs in favor of a change. The next is the child's adjustment to home, school, and community. It's a difficult thing to compare summer visitation with dad with the school time visitation with mom, because the court isn't really seeing behaviors or behaviors in similar situations. That said, the testimony the court received, and there's no contrary evidence, is that the children in school in Arizona are thriving, they're doing well, they're doing better in dad's home, though they certainly miss their mom, and the youngest, of course, most of all. But they seem to be well adjusted in dad's home and have been for some time. They are not well adjusted at mom's home in any sense that the law contemplates. Their turmoil and instability is, I think, well documented by the evidence here. Highly competent and smart children are failing. They're changing their educational settings frequently. There's disruptions and upset at home. There are the loyalty binds that the court has noted. The children simply are not well adjusted in mom's home at this time. While there is some evidence that on a reduced load, Rosalie has regained her footing slightly, that does not, in this court's view, mean that the struggles are now in the past and are not to be considered. Instead, if anything, the court sees these last 2 years as an unfortunate increase in the turmoil that the court saw in 2016. Again, this factor, I think, weighs in favor of granting Todd's request. E, the character and circumstances of all individuals involved. I think both parents are of good character. I've talked about mom's enmeshment in other factors. I'm not going to consider that again as part of a character or circumstances situation. Also, I'm not going to hold against her the issues related to domestic violence. I don't consider E to be a factor. I think that's a wash. I think both parents are good parents. F, the need to provoke continuity and stability in the lives of the child or children. This is an interesting factor because on the one hand, if the court grants Todd's request, that would be a great change, which itself would mean not continuity or stability. The court has had a number of these types of cases, and the court has always come to the conclusion that that is not the focus here. The question is promoting continuity and stability. If a change in and of itself is said not to promote continuity and stability, then essentially that would always prohibit a change of custody. I don't think that's what this factor is going at. The question is, which home or what schedule will promote continuity and stability in the lives of the children? I think Mr. Michelson's home is very stable. There's great continuity there. Their family setup and structure is outstanding. The kids seem to thrive and do well when they are in it. And though Mr. Michelson and his wife may have changed residences several times, as the court has observed, a geographical change does not mean there's not continuity and stability. That home, I believe, has been very consistent and stable for a long time, and the children benefit from it. On the other hand, there's not continuity and stability on the last 2 years with the children with mom's home. The children are struggling. There have been significant changes, and I'm not going to beat a dead horse by re-articulating them. Again, the evidence suggests this has affected Rosalie the most, Christian next, with less or sometimes no evidence as it relates to Caleb. In fact, the evidence suggests a change might actually be difficult for him. So it is with some reservation that the court finds that this factor actually favors Todd's request, but that highlights something the court will get to in a moment. The next factor is domestic violence, whether or not in the presence of a child, whether or not that's present in a home. I will note in passing that there has been domestic violence in Tina's home. But again, it's my long-held philosophy that I will not hold that against a victim of domestic violence, and so therefore I'm not going to weigh this factor against Tina here. So on balance, the 32717 factors actually strongly, in my view, support granting Todd's request in part. We'll turn then to the Tropea factors. Idaho Code 32717 provides that a court can give direction for care, custody, and education for the children as seems necessary or proper in their best interests. That regarding custody, including decisions relating to where the children will reside, the court is required to determine and consider all relevant factors, and all this is from Dante versus Dante, a famous Idaho case, and Roberts versus Roberts, a similarly well-known Idaho case. While the 32717 factors identify some of those factors which may be relevant, additional factors not enumerated may be especially relevant when deciding whether to permit children to relocate. But there is no pre-approved laundry list of factors, according to Idaho law. And that's from Bartos versus Jones, as well as Roberts. Instead, the parties are free to suggest, and the trial court is free to consider factors unique to each case. And the Idaho courts have cited the Tropea factors coming from a New York case entitled The Matter of Tropea versus Tropea. And in Roberts, the Idaho Supreme Court upheld a magistrate's consideration of those factors used by other states to determine when relocation may be in the best interest of the children. And I'll go through those factors now. The factors include the extent of the child's contact with his or her parents. There's no doubt that if I approve the change, contact with Tina will be greatly reduced to the detriment of the children. They have a great relationship with her, the youngest in particular, but all of them. The court is also mindful that Rosalie is now of an age where a mom, while a person she may have conflict with, is an essential person in her life for issues related to her own personal physiology and changes. And that while Jolie will be an important female role model, Jolie is not her mom. That said, there has been a historical lack of contact between the children and Todd, and this will permit, finally, those relationships to form and develop. The court considers this to some degree a wash, but it provides some special considerations that need to be taken into account. The next is the parents' motives for relocating or opposing relocation. Again, I can't fault Tina as a mom for saying I don't want the kids to go. I'm a parent myself. I couldn't imagine that occurring. And it's kept me up at night, I'll be honest. It's a difficult thing for a court to consider ordering. So I don't ascribe any ill will to Tina for saying the kids want to stay home with me. Any mom would say that, and I just refuse to hold it against her. I don't think she has a bad motive for opposing Todd's request at all. I simply don't believe that's true. I also don't think that Todd's motive is vengeful or to get back at or impair Tina's relationship with the children. So I don't see bad faith, which really I think is what this tropea factor is aimed at. It lets the court look underneath the request to determine if it's being made for purposes of deprivation or not. I don't believe that's the basis for Todd's request. If that was the basis, he would have raised it at our last hearing in 2016, in my view, or would have raised it before. The next one really is the greatest factor, the impact the move would have on the child's relationship with a non-custodial parent and extended family. This will definitely interfere with the relationship with mom and with her extended family. Of course, on the flip side, it will improve and finally create an appropriate relationship between the children and dad and his extended family. And as the court has observed, just as the children gain great benefit from their Idaho family here, the children will now have an opportunity to gain a greater relationship with Todd's family in Arizona. I cannot, however, set aside, though, the fact that this factor does not talk about the new custodial parent and their family. It talks only about the impact it would have on the non-custodial parent. And so I have to find that this factor weighs against Todd's request. The next factor, though, I think is very illuminating. The extent the move would enhance the economic, emotional, or educational well-being of the custodial parent and the child. Though this factor is often what we call the job factor. In other words, sometimes a parent has to move for a job just to make their life better for themselves. And that clearly isn't what's going on here. Neither parent is doing that. It does, though, talk about enhancing the emotional and educational well-being of the children. And I do think that the stability provided in the setting in Arizona would enhance the emotional and educational well-being of the children. Again, on a differing scale. More perhaps for Rosalie, a little bit for Christian, and certainly less for Caleb, and troublingly so. Having weighed all of the factors, it's clear to this court that something has to change. What is also clear is that, supported by testimony, the children normalize and succeed in Todd's home. And in this court's view, the instability and conflict has gone on for far too long. And unfortunately, in this circumstance, the court has very few tools to be able to change that. The parties don't live close by to each other, so I can't simply tweak a custody schedule to provide a little more time here or there. The only real thing the court can consider is a change of primary custody during the school year. I also find that the parents are good people. I have always been impressed with Tina and with Todd. They don't have handicaps, addictions, mental illnesses that the court is aware of. Unfortunately, what that means is those aren't things that can be targeted as problems and then ameliorated. Instead, the court really has only one way to remedy the significant disruptions here. And it's a change that in this court's mind will foster a stronger relationship with Todd. And as a result, the court finds to a clear and convincing evidence standard, much as I indicated in my prior ruling that if things did not improve, the likely result would be more time with Todd. The court finds they did not improve, and they have gotten worse to the detriment of the children. Thus, Todd's petition is granted in part. And the part that will change is this. Mr. Michelson shall be the primary on-duty custodian during the school year. However, the parties remain joint legal and physical custody. Mr. Michelson's request for supervised visitation is denied, and instead the schedule of the prior case management order is, on an interim basis, simply reversed with provisions for Todd now applying to Tina. Again, as I noted, the parties shall retain joint legal and physical custody. However, to prevent the disputes that have arisen, Todd shall have final decision-making authority regarding educational and health issues. That is not the same as sole legal custody, Mr. Michelson, and you need to understand that I expect communication between the parties regarding these issues. The court is also going to appoint a parenting coordinator who will be empowered to work with the parents to determine a workable holiday schedule and workable summer visitation schedule for Tina and the children. And on an interim basis, I'm reappointing Fonda Jovic as the parenting coordinator, and I'm awaiting confirmation from her. If she does not confirm, the court will select a separate parenting coordinator. The court further orders that the children shall be immediately enrolled in counseling. And Todd is directed to consult with Tina regarding that selection. And any plan regarding the children shall be developed therapeutically with the children's counselor's input and their needs in mind. Todd, you're going to need to be flexible regarding the needs of the children, particularly in the interim and short term, because they may have different needs. Caleb, for instance, may have more difficulty than the other children, and you need to be respectful and flexible for that. The prior phone contact schedule is abolished, and Todd and Tina are encouraged to create a more child-appropriate contact schedule. The parenting coordinator shall be empowered to enter orders on this issue as well. In the interim, until an agreement is reached by the two of you, the children shall be permitted to contact their mom by phone or video chat every even-numbered day. I wanted to do every other day, but that would be so difficult that disputes would arise as to what day to calculate. So for every day where the number is an even number, they're permitted to have contact with mom. Contact shall be set at a time either agreed by the parties, or if not agreed by Todd, or if no time is set at 7:30 p.m. Unless agreed otherwise, contact outside of that time shall not be permitted, as the historical undermining communication has been toxic in this case. Also, to the extent that the children are to travel to visit Tina pursuant to the custodial schedule, Todd shall bear all costs of transportation for the children for holiday visitation in Idaho with Tina, and those arrangements shall be made per the prior court order. Further, the court orders that the parties shall sign up, pay for, and use a website called Our Family Wizard, which is used to assist in conflictual communication cases. The court will enter a more detailed judgment consistent with this decision that I simply didn't have time to create on our shortened calendar here. Todd, I've granted your request in part. What I have done, though, because I am not the parent, I'm just the decision maker, is the weight has truly shifted to you. And not just to co-parent, truly, but to heal. That is the job that the court envisions for you, to heal your relationship with the children and to continue and preserve their relationship with their mom. That is of the utmost importance. I'll try to keep my composure here as I make these comments, Ms. Nicholson. I want you to know that this decision is not made to punish you in any way, though it may to you feel like that, and I certainly don't intend that. I want you to know I didn't do this lightly. I myself am as a parent, and I could not imagine having the order that I am articulating today. I couldn't imagine having it entered. I do it with a heavy heart. But again, as I mentioned, the measure for this case is the children, Rosalie, Christian, and Caleb, and they are not doing well. And this is the only tool really I have to address that. And I'm going to ask you to do something really hard. I'm going to ask you to embrace this and to be loving and supportive of them with their time with their father. I know that's an incredibly difficult thing I ask of you. But I do that because if the prior behavior continues, it will only enmesh them further and it will only harm them further. I don't expect you to be happy about the court's decision. I don't know how a parent could. But I'm calling upon your greater self that I know you possess. I also want to end on a note of hope. I think every child case should. I have entered this decision today because I believe it is the best plan by which the children can blossom. so they can have stability, so they can succeed and be the wonderful children they deserve to be, so they can develop a relationship with their father, and so that their relationship with you can be fostered and preserved. And I hope you and Todd embrace this and you work together with the parenting coordinator to create a workable schedule that preserves your important role in their lives. And believe me when I say I saw no other way to achieve the success of the children. I also wanted to talk briefly about timing. I would hope this matter is not immediately relitigated. While this court doesn't believe in setting hard and fast timing rules, I would imagine absent unusual circumstances, the court would be very reluctant to reconsider this order prior to a minimum of 2 years. They need a period of stability. This is the decision and order of the court. I want to thank the parties. A formal order and judgment will follow. Mr. Michelson, do you have any questions regarding the decision and order of the court today?
No, Your Honor. I'll just coordinate with Tina regarding the children's personal belongings, but I don't expect you to address that at this point.
All right, thank you. Counsel, do you have any questions regarding the court's decision today? No. All right. I want to thank you both again. I wish you all the best of luck. And the parties are excused at this time. Thank you, everyone. Thank you. I'm going to terminate the connection at this time.